And it's a continuing corruption and perversion of the Justice Department in service of Donald Trump's personal interests. It's really insidious here because he's very clearly going to try and shield all of this information and discovery. And you know what? Like, the right answer here? Walk away, friend.
Yep.
Welcome to Law and Chaos, where the feds are riding to the rescue in Trump's misbegotten troll suit against the BBC. The Trump administration is inventing new ways to steal due process from immigrants, and state judges have had it with the Supreme Court. We've got a lot to cover, so let's get after it. Hey guys, I'm Liz Dye, and with me as always is Andrew Torres. Andrew, how are you?
I am good, Liz. I was finally able to go outside today and breathe the air in Baltimore, which is kind of nice.
Yeah, I'm not sure how long that's going to last.
I choose to look on the positive side. Mm-hmm. I'm also maybe riding high after a certain cribbage match that occurred on Sunday.
This man is so excited. This man is so excited. And it's great. It's wonderful to see.
And in law news, I was a guest on the Make It Make Sense podcast with Grant Herms, and we will link that in the show notes. And we have the special monthly bonus episode for our paid subscribers. This one is on the trolley problem. So if you've ever wondered, would you kill one person to save 5? This episode is for you.
I have never.
Really?
Wondered.
You should be thinking about it. It's one of the classic problems of philosophy.
No, I have thought about it, and I am not going to tell you my very well thought out solution to the trolley problem. Instead, I am going to give you
Dun-dun.
Ducket Alerts. Okay, first up, let us all raise a glass to the Minnesota legislature, which passed the grandparents' happy hour last week, making it legal for nursing homes to serve alcohol to residents during social events.
From which we can infer that it was not legal before this?
Good Lord. Americans have such a weird attitude toward alcohol. Like, just for comparison, I searched for alcohol instruction on care homes in England. That's what they call them there. It said, "Can I continue to drink alcohol when I move into a care home?" Yes! Exclamation point. For many older people, drinking alcohol is an enjoyable part of a happy life. Your care home is your home, and you should be able to drink if you want to. Many care homes provide alcohol. For example, staff might serve it at mealtimes. There may be a bar within the home or a drinks trolley. Alcohol, or a certain amount of alcohol, may be included in the care home fees, or there may be an additional charge. You should ask about this before you move in. And that same guidance has a section that says basically, the fact that you have a medical condition, which means that you should not drink, is not a reason for the staff to deny you alcohol, because you're entitled to the dignity of making your own choices.
Can we be a country that respects the dignity of our elders to make their own choices?
Yeah. Like, let these people have a glass of wine with dinner. They're 81. They're not 21, you know?
Yeah.
Okay. Next up, Exhibit 11 million, DOJ versus basic legal competence. This one is out of Massachusetts, where the federal government sued Governor Maura Healey, along with the state attorney general, the secretary of transportation, and the registrar of motor vehicles in May. They alleged that the state violated the supremacy clause of the Constitution by refusing to issue undercover untraceable license plates to ICE agents.
Yeah, I am reasonably certain that this falls under the same category as all of the administration's other sanctuary jurisdiction cases. We've talked about this on the show at length. That is, no, the federal government does not get to commandeer state resources to carry out federal law. This is just basic 10th Amendment stuff. Although there could be more to it. I guess it could be statute specific.
Well,
right?
We're not going to find out, at least not today, because the DOJ just plumb forgot to respond to a motion to dismiss that was filed on June 29th.
Absolutely amazing work out of the Department of Justice's Civil Division. Look, the local rules say that you have 14 days to respond to a motion to dismiss. Now, I should be clear on that. Under the Federal Rules of Civil Procedure, the default is you have 21 days. But everybody who practices in any jurisdiction knows that that can be shortened on a jurisdiction-by-jurisdiction basis. And the first thing you do before you appear in a court is you read that court's local rules. And it took us like 8 seconds to find the Massachusetts local rules that say you have 14 days to respond to your motion. And I don't know what happened here, but apparently the government just didn't.
Yeah, I looked at the docket. The government actually objected to a request for extension filed by the state. They wanted more time, and the government said, no, the United States desires to efficiently pursue this litigation to enjoin the harm caused by the Massachusetts RMV, the Department of Motor Vehicles, new policy, including sovereign injury, endangerment of federal officers, and disruption of federal law enforcement operations.
I love it. I mean, no wonder Judge Young just booted the government out when it failed to file, right? Instead of typically what would happen if you missed a deadline, you'd get a friendly or less than friendly reminder on the docket. But like, you litigate like a jerk. The court treats you like a jerk, even when you're the federal government.
And speaking of the DOJ falling on its face.
I can speak about that all day.
Yeah. There was a hearing this morning in D.C. Superior Court where former Olympian Davy Hearn is charged with sabotaging the Lincoln Memorial reflecting pool. This is another Jeanine Pirro special, and it is already circling the drain.
I see what you did there. So obviously, this case is bullshit. But we're not just laughing here, right? It actually does illustrate some really important things in criminal law. So start with the defendant's right to a speedy trial. That is one of the core rights guaranteed by the Sixth Amendment. Each jurisdiction in the United States interprets that differently. So federally, the rule is set by statute at 70 days from indictment. That's when the government has to go to trial. In D.C. Superior Court, which is functionally a state court, but D.C. is not a state, it's 100 days. And even though it's functionally a state court, the federal U.S. attorney for D.C., the aforementioned Jeanine Pirro, still handles prosecutions because, again, Washington, D.C. is not a state, although it should be. Now, in a lot of ways, this is academic, right? Because typically defendants want lots of time to prepare for trial. And so the government and defense counsel jointly agree to suspend the speedy trial requirement. And the federal speedy trial statute exempts time spent in which the court is adjudicating dispositive motion, right? Like it's almost never actually 70 days from indictment. But in D.C., defendants who have been ensnared in these absolutely bogus prosecutions are instead pressing the pedal to the metal and demanding to be tried immediately. No suspension, no agreements to postpone. And I think that's pretty clearly a bet that their fellow jurors are currently super pissed at the federal government and will vote to acquit, and that any trade-off of, well, maybe I'm less prepared for trial is more than outweighed by, no, let's get this in front of juries while they're still mad.
Yeah, and that's a bet that's paid off. Remember the sandwich guy, the hoagie hero? That's the dude who threw a Subway sandwich at the CBP agent and said, "I did it. I threw the sandwich," and then he got acquitted. There's like a dozen examples.
It's hard to lose that case.
Right. And so Hearn, in this case, is like, giddy up, let's go. But so this morning, there was a hearing, and his trial was set for September. I forget the exact date. It doesn't matter. This case is never going to get to trial because, once again, the Trump administration is the gang that cannot shoot straight.
Are you telling me, Liz, that, say, destroying the crime scene makes it harder to prosecute?
That is indeed what I am telling you.
Go on.
Hearn's legal team filed a motion to dismiss the case on Friday, noting that they sent a preservation letter to the government, after which the Park Service drained the pool and said they were just about to repair it.
Yeah, the exhibits to this motion show that the entire pool liner is wrecked, of course, that the damage is worst at the seams, and that in the corner of the pool where Davy Hearn is supposed to have ripped it up, there's a 3-foot patch missing.
Yeah, if they're saying he pulled up this patch, where is it? Right? Giant chunks of epoxy don't just like wander off, swim away, right?
Right.
I don't think the ducks stole it.
So, just to clarify, one, that is the state of the pool, is absolutely Brady evidence. It is potentially exculpatory information that might exonerate Hearn, right? So the government has a constitutional obligation to turn over stuff that might prove the defendant's innocent, right? Not, say, cover it with water.
Right.
And two, the statute here requires the government to prove that Hearn did $1,000 worth of damage, right? That is an element of the crime. If they can't prove $1,000 worth of damage, he is not guilty of the crime for which he has been indicted. So Hearn would like to run forensics tests to establish that the damage that they're saying exceeds $1,000 occurred some other way. But Hearn can't do that if the government drains the pool and gets Trump's pool boys back in to recode it. Like, even a demented Fox News host ought to know better than that.
Yeah, and yet, no. So I don't know what's going to happen here, but I suspect that this case is
motion to dismiss. That's what's coming.
Well, the motion to dismiss was filed. I suspect this case will die on its own in August before it ever gets near a jury.
Yeah.
Okay. In California, Judge Araceli Martinez-Olguin issued a temporary restraining order blocking the Paramount-Warner Brothers merger.
Yeah, this is the antitrust case brought by 12 states seeking to block the merger after the Trump administration greenlighted it. The easiest argument, the one that the states are leaning into the hardest, is that combining two of the 5 biggest movie studios will necessarily reduce the number of blockbusters produced and thereby increase the price that consumers pay at the theater. There was a hearing on Friday, and Paramount's argument amounted to basically Amazon is going to pick up the slack and make more blockbuster movies if they're less coming out of Paramount, Skydance, Warner Brothers. And it was just a terrible argument, right? Because speculation about some future market solution that might materialize to ameliorate the negative effects of your anti-competitive monopoly, that by definition is not going to ward off an antitrust suit, particularly when allowing the companies to close to complete the merger would potentially moot the case. So the case will proceed to a hearing on a preliminary injunction on August 3rd, unless the parties agree to keep the temporary restraining order in place and push out that date.
Yeah, remember, a TRO can last for 14 days, and it can be renewed once by the judge. So you max out at 28 days. Mm-hmm. A preliminary injunction, though, that will lock in the status quo until trial. So in August, Judge Martinez-Olguin will decide the motion for a preliminary injunction, and that's really all of the marbles here. Because if Paramount doesn't close the Warner Brothers deal in September, they're in deep shit. Yeah. Because they already agreed to a $650 million ticking fee for every quarter that the deal doesn't close. That is, they have to pay, I think it's like a 25-cent per share to the shareholders, a fee. And that starts in September. So that'll be every quarter. Plus, they're going to owe a $7 billion fee if regulators kill this deal entirely or the court. And Paramount's debt just got downgraded to junk status because of all of the debt that it took on for this merger. So if they can't, if this PI does in fact issue in August, that's going to be really a big deal for Paramount.
And the reverse is true, right? If the PI does not issue, then the merger completes, and the case might still go forward. But the court, California court, is not going to unwind the Paramount Warner Brothers merger. That's not going to happen.
Okay, and now it's time for the Law and Chaos doofus of the day, Darline Graham.
You doofus!
Wait. Darline Graham? I'm pretty sure 3 days ago was Darline Nordone.
I think it was Darline Graham Nordone, but now she's decided she actually does want to run for senator to replace her brother, Lindsey Graham, who obviously died last week. What do you think about this one, Andrew?
I think while South Carolina Governor Henry McMaster is not our doofus of the day, he is perhaps the person who has been most stabbed in the back by this.
I mean, he definitely got mugged here.
Yeah.
So we talked about this on the show last week. After Graham died, there was this kind of tug of war between the White House and South Carolina Governor Henry McMaster, who has the right to appoint an interim person to hold the spot. And Trump kind of bigfooted in and said, it would be appropriate for you to appoint Lindsey Graham's sister as a placeholder. And we interpreted that as him wanting to play kingmaker and not letting McMaster put somebody in there, because then that person, if they were running in the election, the general election in November, that person would have a huge leg up on anybody else because they'd get to say, I'm the incumbent.
Right. And so this was essentially playing fair, right? I mean,
not sure I think it would be playing fair if fair is Trump, get to decide instead of the governor of South Carolina.
Yes, it is still Trump usurping a state governor's powers, but it didn't put his thumb on the scale. And then on Friday, Donald Trump announced on Truth Social that he would endorse Darline if she would announced that she was running for the full term in the primary election in South Carolina, which is scheduled for August 11th. He said, "Run, Darline, run," which I was that a deliberate callback to Forrest Gump? I don't know.
I don't think so, but I definitely think this is like a huge bait and switch. Everybody understood she was a placeholder. And then Trump was like, well, you seem like you're pliant, and I have no respect for the voters of South Carolina, so I choose you. So that's I assume that she's going to win. It's a very, very Republican state. She's certainly got she's got the name.
Yeah, in terms of how this shapes up, Nancy Mace was a potential candidate in this race. She has now dropped out. There are two other named candidates who have already announced their intention to run. That is Republican Representatives Russell Fry and Ralph Norman. The Democratic candidate is Annie Andrews. I like her a lot, but I think she's got a pretty uphill climb here.
I do indeed. I'm interested to see if Fry and Norman want to run, they're going to have to not run for Congress. I think they're both sitting members of the House. So, it's not just that you would have to go up against Trump. It's that you would have to give up your job. You'd have to give up your House seat to run. So I do not know. I wonder if that has anything to do with Trump endorsing.
That may be why he wanted to clear the field. That's a good insight. I
do not know. All right, we're going to take a quick break, and then we will come back and we will discuss Trump's lawsuit against the BBC and the DOJ trying to jump in and save him from his own terrible lawyering.
And we're back, and since it is Tuesday, this is when we give a shout out to all of our supporters. So big thank you to our subscribers on Patreon over at patreon.com/lawandchaospod. Thanks to Jeremy Krall, Justin Hartman, Frustratio, SL, Joshua Garfinkel, Dallin Zollinger, Zachary Drathman, and Ariel Anderson.
And over on Substack at lawandchaospod.com, thank you to Linda Niles, Jan Sherwood, Klaus Lewis or Lewis Klaus, I wasn't entirely sure, but thank you. Thank you to both of you. Pauline Farmer, John Gill, Tim Poppleton, and Karen Tissanai.
And if you want to join their ranks, you know how to do that. Just head on over either to lawandchaospod.com or to our Patreon, patreon.com/lawandchaospod. Sign up, give us as little as $1 an episode. We will give you a shout out here on the next Tuesday. We will give you the ad-free episodes. We'll give you the bonus episodes. We'll give you everything we can find, as well as our sincere thanks for helping make this show possible and letting us to continue to do this thing that Liz and I love to do so very much.
Thank you, guys.
Okay. Let's talk for a bit about Donald Trump's lawsuit against the British Broadcasting Corporation, better known as the BBC. Liz, you wrote about this on our blog, but I do want to talk about it on the show because, once again, Donald Trump's Department of Justice is trying to horn in on civil litigation in which he has a solely personal interest in order to save him. Liz, as our resident queen of Donald Trump defamation troll suits, I kind of feel like I should maybe just step back and let you do your thing.
That is indeed my claim to fame. Okay, so we all know that Trump files garbage lawsuits against media outlets all the time. He's currently suing the Wall Street Journal for saying he drew boobs on a birthday card to Jeffrey Epstein. He's suing the New York Times for writing about tax shenanigans involving his father's estate. He's suing the Des Moines Register for whiffing a poll. He's trying to get the Supreme Court to revive his nonsense suit against CNN because it's defamatory, to use the phrase, the big lie.
No, it isn't.
No, it's not, which is what every court on earth has already said. But because Trump has the power of every federal agency behind him, he has been able to get some companies to pay him millions of dollars to settle garbage lawsuits. Pay to his presidential library.
His non-existent presidential library.
Yeah. So around the time of the 2024 election, the BBC aired a documentary that spliced together clips from Trump's January 6th speech to make it sound like he was exhorting his supporters to sack the Capitol.
I mean, that is clearly how they heard it.
Right. But no one noticed this documentary on the BBC because it was never available in the US. And also, like, who cares, right? Like, how could this possibly harm Trump? Nevertheless, he filed a lawsuit against the BBC in the Southern District of Florida, seeking $10 billion, and he managed to land on the friendly docket of Judge Roy Altman, his own appointee. So to start off with, the BBC says, we would like to stay discovery in this case until after our motion to dismiss for lack of jurisdiction is decided because discovery is going to be really burdensome. And Judge Altman says no.
Yeah, which is not how this usually goes. I mean, to be clear, there is zero jurisdiction for this case to take place in Florida. This documentary never aired in Florida. And Liz, as you point out, discovery is not just unpleasant, but highly expensive. And nevertheless, Judge Altman said, yeah, go ahead, Donald, take your free hit on the Beeb, which is the way the cookie crumbles. But it legitimately does not seem to have occurred to the president or his lawyer, Alejandro Brito, that discovery goes both ways. So, having lost, the first thing the BBC does is drop subpoenas on everyone in the Stop the Steal movement, everyone who worked in government close to Donald Trump, close to Don Jr., Ivanka, Jared, and as well as on 12 different federal agencies. Plus, they want all of his financials because, again, as you pointed out, Liz, Trump has claimed he was damaged to the tune of $10 billion. And in order to get that, you have to prove that you were financially harmed.
So Trump goes apeshit. His lawyer files all these motions complaining that the only issue in this case is whether the BBC altered what he said, and none of that other stuff is relevant. But of course, that is not the only issue, right? The issue is whether it was false, because this is a defamation case and you got to prove falsity. The issue is, did he intend for his supporters to riot, irrespective of whether the footage was edited? And so the question of whether people around him said, you cannot say that, sir, because it will cause a riot, your supporters are going to do things violently, is wholly relevant,
yes,
as are his finances, obviously.
Yeah, and at the same time, you have another problem, which is that Alejandro Brito is in no fashion set up to go to war with the BBC's lawyers, the mega firm of Ballard Spahr that has 750 lawyers in more than a dozen offices in a case that will be hugely discovery intensive, right? It is literally insane to demand $10 billion and then whine that the company that you've sued has issued 50 third-party subpoenas. Like, of course they have. That's their job. They have an obligation under the model rules of professional ethics to litigate that case diligently. Like, there are going to be millions of documents produced. There will be dozens, maybe over 100 witnesses deposed. There will be collateral litigation in multiple jurisdictions over the third-party subpoenas. Like, that is how this game is played.
Right. I mean, I'm not saying like, oh, this guy's a jackass, ha ha. Right? Brito, runs an 8-lawyer shop. He does not have the compute to do this. I mean, to borrow a metaphor from AI, he doesn't have the manpower.
Yeah.
So Trump's side basically doesn't produce anything at all in discovery. And Brito misses some deadlines, and when he does file, it's just like boilerplate objections. He refuses to admit or deny that Trump talked to Rudy Giuliani or to Steve Bannon or anyone else. And like, he's clearly flailing in this case.
But here comes the cavalry, because last week the Department of Justice filed a statement of interest in the case, citing 28 U.S.C. Section 517. Now, statement of interest filings are indeed a real boring, everyday tool. Here is the way that every administration before this one has used them. I know, because I litigated this case. So I had a property dispute between two neighbors, and one of the neighbors claimed that the boundary line on the property was on a federally protected wetland. So the court in that dispute was called upon to adjudicate whether that was true or not, whether it was actually a wetland. And so the Environmental Protection Agency filed a Section 517 notice and said basically, hey, this court might be called upon to adjudicate a statute, and we think you should know how we would interpret that statute. So agencies use Section 517 to tell a court that private litigation is about to intrude on the turf that statutes that the agency enforces, and to then give their view. And this is a way, it's a stronger way than, for example, filing an amicus brief, which is something else they could do. So If the BBC case were actually about the federal agency's own, I don't know, their document retention policy or something, then fine, this would be appropriate. But that is not what happened here. Instead, the Department of Justice filed an omnibus Section 517 notice, and what they want to do is use all of these subpoenas on federal agencies, as well as individuals who are not federal agencies, as a wedge to try and insert the government into this civil case to then take the burden off of Brito because, as you point out, like he just can't handle this. It does not have the compute, does not have the capacity. The DOJ also wants to contest the subpoenas on former federal employees and non-employees like Steve Bannon.
Well, remember, Steve Bannon asserted executive privilege.
Right.
That's why he went to jail for contempt of Congress, because he said, I'm asserting privilege over my conversations with the president.
Yeah, how'd that
People
go
are like,
for you, Steve?
No, you cannot do that. You are not an employee of the president, and that's not a thing. So
right.
He went to jail.
So, and I should add, there is a mechanism to contest subpoenas on government agencies, and this is not that, right? Every federal agency is required to propound what are called TUI regulations. Those are internal rules for how their employees will respond to subpoenas in cases that the agency itself is not a party to. So if I subpoena the FBI for records in a private lawsuit, I don't just serve the subpoena and wait because I'll never get an answer, right? I submit what's called a TUI request. It's basically an application to the agency's own counsel explaining exactly what I want and why. And then the agency decides through its own internal regulations whether to authorize disclosure. That's what the BBC did, and that part is ongoing. But in the meantime, the DOJ wants to wrap all these things up as a means to get itself inside this flailing lawsuit.
Right. And to be clear, the reason that it wants in, aside from the fact that Brito can't do it, it's more than about fighting the subpoenas, because Trump is getting ready to claim that everything the BBC wants in discovery is covered by executive privilege. He's going to say he can't disclose anything, and neither can the federal agencies, and neither can Mark Meadows, like his former chief of staff, because all of it is covered by executive privilege. Now, of course, Donald Trump could disclose anything he wants because he's the one asserting the privilege. And now he wants to do that as a shield to protect himself in this civil lawsuit that he filed.
Yeah.
And related to this, in D.C., there is this other privilege fight going on because the BBC, obviously, and they're very good lawyers, can spot this a mile away.
Yeah.
So this fight is about the special counsel investigation into Trump's election interference. Specifically, Jack Smith went to the federal court in D.C. and litigated some of Trump's claims of executive privilege with respect to Mark Meadows and Mike Pence and former White House counsel Pat Cipollone years ago.
Yeah.
And they didn't want to be forced to testify before the grand jury, and it was argued before then Chief Judge Beryl Howell, and she basically said no and found against privilege with respect to a lot of these discussions. So the BBC now says, we would like to unseal those rulings that said, no, Mark Meadows, you have to testify to the grand jury because this information is not covered by executive privilege, because that would head Trump off at the pass. He wouldn't be able to claim privilege over these discussions if a court had already said that they were not covered by privilege. And that's a thing that's ongoing. But I think I want to step back one click here, because this is really...
I really wanted to get into Rule 6E and disclosing grand jury transcripts.
I know, grand jury material. Right. Yeah. You're not supposed to see it. But more to the point, we have seen this game before during the first Trump administration when E. Jean Carroll sued Donald Trump in the state of New York for defamation. And it was right after the state judge had said he would have to give a DNA sample, get a cheek swab. Bill Barr moved in under the Federal Tort Claims Act, the Westfall Act. Yeah. These are sort of related statutes and said, no, the federal government has to be the defendant here because Donald Trump was acting in his professional capacity as a president. He was acting in his official capacity when he said that E. Jean Carroll was too unattractive to sexually assault. And multiple courts said no. That's how they got into federal court, where I think that they would have preferred in the long run to not be in federal court because Judge Lewis Kaplan was very unfriendly to that case. But that we saw in his first administration, the DOJ jumping in to save him in civil litigation. And actually, when Trump came back into office, his new DOJ, Pam Bondi, tried to reassert that kind of Westfall determination and say, no, we really are going to be the defendant in this case. And to be clear, if the government had successfully intervened and substituted itself as defendant in the E. Jean Carroll case, the E. Jean Carroll case would have gone away because you can't sue the federal government for defamation because it hasn't waived sovereign immunity. And look, this also has an absolute similarity to the ongoing slush fund litigation where Trump was on both sides of that dispute. And it's a continuing corruption and perversion of the Justice Department in service of Donald Trump's personal interests. It's really insidious here because he's very clearly going to try and shield all of this information and discovery. And you know what? Like, the right answer here? Walk away, friend.
Yep.
You didn't have to wander into this lawsuit. You're not going to get any money. It's the dumbest lawsuit. It's going to get dismissed on jurisdictional grounds. And now you're going to try and burn everything down in a privilege fight. Walk away, man.
Yep, I agree.
Okay, we are going to take a little break unless you are a subscriber at patreon.com/lawandchaospod or lawandchaospod.com, in which case we're going to talk about an actual real defamation case, or realer than this one, filed by Madison Square Garden against Wired reporters Noah Shackman and Maddie Varner for their reporting on the Big Brother surveillance system, which basically captures the information of every person who walks into Madison Square Gardens. Do not love it. For everybody,
but I love our segment.
But I do love our segment. For everybody else, we will be right back after this brief ad break.
And we're back. So, Liz, on Friday, as I said at the top of the show, I was a guest on Grant Harms's podcast, Make It Make Sense. And what we did was review the 2025-2026 Supreme Court term. And we know what that term was like. And at the end, right, after we went through all of the terrible right-wing judicial activism, he asked me the question that you and I get asked a lot, I mean, maybe more than any other, right, which is, okay, is there still the rule of law, right? If the Supreme Court is this broken, why does any of this matter? And I have to confess, I stole your point about how federal district court judges are holding the line. They are doing the hard work. I don't think it's
my point. It's the topic of this show week after week.
But I want to give you credit here. And look, that really does. It has made a real difference. And I highlighted some of the immigration cases, right? So all of that is true. But another way in which the rule of law is still real is in state Supreme Courts. We've touched on this before, but as the United States Supreme Court continues to retreat from federal constitutional protections, state Supreme Courts can, and in many cases are, stepping up to fill some of those gaps.
So this is one such case. It's called Granillo v. Hawaii, and it's from the Hawaii Supreme Court. The underlying merits are actually really interesting. It's about what a court should do when evidence that was used to convict a criminal defendant is later discredited as junk science. But it's also about one state Supreme Court judge saying, going apeshit and saying the Roberts Court is broken, which he's not wrong.
This is the most bitter, technically unanimous court opinion that I have ever read. So let's get into it.
Okay, in 1989, Daniel Granillo was charged with kidnapping and sexual assault. At trial, an FBI agent was called to testify as an expert witness in hair and fiber analysis. That Agent Oakes testified that a hair sample found in Granillo's car had the same microscopic characteristics as the victim's. He also testified that fiber samples found in the victim's underwear were microscopically identical to the fibers in Granillo's car seat cover. And from that, he concluded that the victim was in Granillo's car undressed. Granillo was convicted and sentenced to 2 consecutive 20-year sentences in prison.
The Innocence Project and the National Association of Criminal Defense Lawyers questioned that underlying science of hair and fiber analysis. They worked for decades with scientists at the National Research Council to investigate the reliability of that kind of science. And finally, in 2017, after much research, the Department of Justice admitted that Agent Oakes' testimony was what they described as inappropriate in that it overstated the scientifically justifiable conclusion. So essentially what the letter said was, this isn't CSI, right? Like, you cannot match hair and carpet fibers as if they were fingerprints and exclude them from being, right? Like, the science does not support that level of inference. Granillo, as you might imagine, filed a motion for post-conviction relief under Rule 40 of the Hawaii Rules of Penal Procedure. And so what he was asking for was to have his guilty verdict thrown out and to be given a new trial. And so the issue that wound up at the Hawaii Supreme Court was what standard state courts should use in determining how serious the error was in admitting Agent Oakes' testimony when it was later invalidated by better science.
And all 5 judges on the Hawaii Supreme Court agreed that Granillo deserved a new trial, but they did not agree on the reasoning. Mm-hmm. The 3-justice majority said that in cases where testimony turns out to be scientifically wrong, the trial judge should grant a new trial if the testimony was material to the jury's verdict. If it could have affected the outcome at all, the defendant deserves to have his case heard again. The concurrence said, no, that standard's too broad. It would effectively undo convictions in every case where later discredited science was admitted in testimony. And so the justices in concurrence argued that courts should treat it like newly discovered evidence post-conviction. Like, look, when you go back and you use DNA to exonerate a defendant. So they suggested a standard that you should get a new trial unless the state can prove that the erroneously introduced evidence was harmless beyond a reasonable doubt.
Yeah, so here's the practical significance. If the state otherwise had overwhelming evidence sufficient to support a conviction, then the testimony that turned out to be scientifically invalid could have been harmless error. So in that counterfactual applied to this case, Granillo, the state argued, would have been convicted anyway, even without Agent Oakes' testimony. And the majority rejected that approach. And I agree with them, by the way. Like, I think we should minimize having judges engage in kind of alternate history in their mind to try and divine how the jury would have come out if X piece of evidence hadn't been introduced. Like, that's just guesswork in a hat. I think courts should be honest. So what I like about the materiality test is that the question isn't a subjective, what do we imagine the jury might have done? It's an objective inquiry. It says, was this a significant piece of evidence put before the jury that turned out to be false? If yes, new trial. But I want to be clear here. This is a real law kind of question, right? Like, I think all of the judges, both in the majority and in the concurrence, tried to do their best to figure out what the law actually requires, unlike, say, a certain U.S. Supreme Court.
Right. And that's all of this stuff about the evidence is very interesting, but that's not why we're talking about this case.
Yeah.
So Article 1, Section 5 of the Hawaii Constitution says that no person shall be deprived of life, liberty, or property without due process of law. That was an issue in this case because it was a question of how much process Granillo was due, right? So this wasn't totally out of left field.
I talk about that in some depth in the subscriber bonus that I just released. So.
Okay. Well, you should all go and listen to that. But so this language about life, liberty, and property without due process of law is word for word identical to the Fifth Amendment to the U.S. Constitution. And for 200 years, state courts have typically read that language. It's called in pari materia with federal court decisions. So the reasoning is if the state copied the language from a federal document, probably the way federal courts interpret that language is how the state of Hawaii or whichever state has it should interpret that language inside its own constitution. Not that it's binding precedent that, the Supreme Court of Hawaii must follow, but typically if the Supreme Court says this is what the life, liberty, or property without due process of law means in the U.S. Constitution, that's what it means in the Hawaii Constitution as well.
Yeah, and that was the case up until the Roberts Court. I mean, for the past decade or so, we have seen state Supreme Courts saying, nah, we're good when it comes to identical language. Right? One example that comes to mind comes from Iowa, where in 2018, that state Supreme Court held that its own Constitution's due process clause, which again was previously read in pari materia with the Fifth Amendment, did protect the right to abortion, regardless of what the Supreme Court might say someday. That decision, the Iowa Supreme Court said, "We jealously guard it as our right and duty to differ from the Supreme Court in appropriate cases when construing analogous provisions in the Iowa Constitution. While we may draw upon precedent from federal courts when persuasive, we exercise our right to conduct an independent interpretation of our Constitution." So I flag that because the right wing is going to say, oh, look, the Hawaii Supreme Court is crazy and out on a limb. And no, like red state courts have said, this is our prerogative. This is a federalist system. We get to interpret our state constitution. And I should say parenthetically, I really want to do a deep dive at some point on the fallout from that decision. The Supreme Court reversed it in 2024. It was after a bunch of Republican appointments. It's incredibly fascinating. But I don't want to lose sight of the point here for this story, which is that as the Supreme Court under Chief Justice John Roberts has become increasingly viewed as illegitimate, state Supreme Courts have done what Iowa did in 2018. They've taken back their rights to interpret their own state constitutions.
Which is what happened in this case. And then the next thing that happened was that Judge Todd Edens ripped open his robe, revealing an FUJR t-shirt.
We should sell those.
Yeah, we run the bank on those. But let's read some of his 91-page opinion.
Okay.
We are doing what state constitutionalism asks us to do. Stand our ground. We interpret the Hawaii Constitution on its own terms. The United States Supreme Court's construction of the Federal Due Process Clause does not define the protections of our state's Due Process Clause. The court that now defines federal due process does not honor the work of 1954. It revives the work of 1857.
Ooh.
Yeah. So the 1857 reference is to the most reviled Supreme Court decision in history, the one that kicked off the Civil War. That's Dred Scott v. Sanford. Judge Edens quotes the part where the Supreme Court upheld the Fugitive Slave Act on the grounds that the Constitution must be interpreted according to its true intent and meaning when it was adopted, and follows with, today's hubristic originalists use the same method to control modern life.
I love this opinion. I mean, look, these 10 pages are dicta. They're kind of shoehorned in, and I get why the judges writing the concurrence were kind of like, what the hell is going on? But I think this is necessary, right? Like institutionally, as a matter of temperament, you don't get to be a sitting judge because you're eager to call Chief Justice John Roberts a hack, right? Like judges are reluctant to say that sort of thing. Judge Edens has had enough, and he decided to make the subtext text. I want to read some more because, to be honest, we could just read this entire opinion for the whole show. He says, what this Supreme Court has done to constitutional rights, democratic institutions, and the rule of law explains why Hawaii's Constitution takes no instruction from it. Hawaii's Article 1, Section 5 provides versatile and sovereign protection. This court does not anchor Hawaii's due process rights on the federal floor, especially one that keeps sinking. We take no guidance on the meaning of due process from a court that gutted due process protections in Dobbs v. Jackson Women's Health Organization.
I mean, he's not wrong.
Yeah. And then he quotes from a Hawaii Supreme Court opinion criticizing Dobbs. That opinion, Zufante said, Dobbs erased a generations-long constitutional right, stripping autonomy from half the population and empowering states to force birth. Article 1, Section 5 does not import that results-driven approach to due process. We follow principles, not agendas. And here.
Yeah, Judge Edens said, the Supreme Court's imperious ideology does not stop at due process. The same jurisprudence has cratered democracy itself. Start with the Voting Rights Act. The Roberts Court did what Congress never would. It rewrote the Voting Rights Act of 1965, a cornerstone of American civil rights, democratically enacted and repeatedly reauthorized. Shelby County versus Holder began the judicial demolition, inventing a textually unsupported equal sovereignty fiction and striking down preclearance on a hunch that the law worked too well. Louisiana versus Calais buried what remained of the crown jewel of the civil rights movement, pretend law for a real statute.
There was so much more we could read, but the dead-on criticism that the Roberts Court pretends to be colorblind, quote, while engineering the erasure of Black history, the lengthy discussion of gerrymandering, describing Rucho versus Common Cause as the court having abandoned partisan gerrymandering to the gerrymanderers. Here. Oh, and Trump v. U.S., which describes parenthetically as placing a president above the law. But here's how the Supreme Court of Hawaii, in its majority opinion, sums up the Roberts Court. Rulings run in one direction time after time, weakening protections for those with less power, fortifying those with more. The pattern speaks for itself. A court that systematically dismantles democratic safeguards, steamrolls constitutional liberties, and tramples human dignity does not chart the course for the Hawaii Constitution. Our constitutional system was designed for times like these. Federalism is not a formality, it is the architecture. The framers built dual sovereignty into the structure of American government as an independent check against concentrated federal power. A Supreme Court driven by agenda and intent on swiping power that belongs to the people is exactly what that check was built for. When 6 justices walk away from those that they are supposed to protect, state constitutions hold the line. That is not defiance, that is the design.
I love it. And also, that is a sign of a judge in distress.
Yep.
Okay, we will be back in a minute with a story about the Trump administration trying to use a secret immigration court for the first time in its 30-year history to get around due process.
And we're back. On Friday, legal journalists discovered the first filing in a court called the Alien Terrorist Removal Court since it was created 30 years ago. That meant, Liz, that you and I got to spend part of our weekend figuring out what the hell this court is, what's going on, why no previous administration has ever used it, how cases before it work, and what Donald Trump is trying to do with it. I do want to jump ahead to the punchline, which is that we do not think that this court is going to be a vehicle for what Trump wants to do, which is engage in mass detentions or deportations of immigrants without due process. But I do think we have not heard the last of it. So let's talk about it.
Okay. So Congress created the Alien Terrorist Removal Court, or ATRC, in 1996 to handle deportation cases in which the government asserted that it was deporting a terrorist and the evidence was sensitive or confidential, involved national security information, and it couldn't be made public. So the idea was to create this separate court to handle that kind of cases. ATRC is staffed with 5 judges who are full-fledged Article III judges serving for life on a U.S. District Court. Chief Justice Roberts picks those judges, selects them to each serve a staggered 5-year term, and then designates one to be the chief judge of the court.
Yeah. That same designation process was also used by Congress back in 1978 when it created the FISA court. So, weird, but it's been done before. And you might be thinking, I know you are, oh boy, staffed by Chief Justice Roberts, I bet that's going to suck. And in fact, the journalist Charlie Savage published a study in 2013 looking at the FISA courts, right, in the New York Times, suggesting that Chief Justice Roberts had indeed stacked those FISA courts with overwhelmingly Republican appointees. So, mixed bag here. I will tell you that the ATRC has 4 George W. Bush appointees on it and 1 Donald Trump appointee, which sounds bad, but as a little bit misleading, right? Because 2 of those Bush appointees are from blue states, including the chief judge, who is Joan Erickson from the District of Minnesota. And the Trump appointee is Karen Immergut from Oregon. If that name is familiar, we talked about her on the show back in episode 174 after she ripped this administration a new one when it tried to federalize the National Guard and deploy it to the streets of Portland. So, bottom line, this court does lean conservative, but not Trumpy. The deck isn't Reed O'Connor and Eileen Cannon are not on it.
Yeah, and just to kind of make subtext text there, the reason it matters that they're from blue states is because of the blue slip rule. You cannot get you cannot get a Reed O'Connor confirmed in like Massachusetts because Massachusetts has 2 Democratic senators and they're not going to return their blue slips.
Right.
And let's be clear, before Trump, judges weren't like this, right?
Right.
We talk on this show all the time about old bulls, and the old bulls pre-Trump, the Republican appointees pre-Trump are mostly horrified by what he's done.
Yes.
Okay. So that is the composition of the court. Here is how it works. In a case where the government has classified information that someone is an alien terrorist, and that's the defined term, then the government has to file an application with the court in which laying out the probable cause to believe that the person it's trying to deport is an alien terrorist physically present in the U.S. and that his continued presence would pose a risk to the national security of the United States.
in the abstract, I don't know that this is a terrible idea. I'm waiting to hear from our buddy Kel McClanahan, but we've talked about the Classified Information Procedures Act, or SIPA, on the show. Right? That statute has problems too, but it was created to cover a real problem, and that problem was gray mail, right? That spies would steal secrets and then basically dare the government to prosecute them, because in order to prosecute them in open court, that would require disclosing those secrets. And so SIPA was created to give a vehicle to get around. I could see how you might want to have a special court to handle deporting spies working with terrorist groups, so long as that court has sufficient protections for due process.
So the first protection is that once the application has been filed, the court has to independently review it to make sure that the government has met its burden of showing probable cause that the person it wants to deport is a terrorist, is in the United States, and does in fact pose a threat to national security. Probable cause is a pretty low standard. It's not a heavy burden, but it's not a rubber stamp.
Right. And in fact, the only thing that we have seen this court do so far is this public ruling from Chief Judge Erickson saying that she didn't find probable cause. So here's what we know, which isn't a lot because these filings are ex parte and under seal, so they have not been disclosed to the public or even to the target that the government is trying to deport. But here's what we've been able to work out. On Wednesday, July 15th, the administration filed an application in this court pursuant to 8 U.S.C. Section 1533A, asking the ARTC court to assume jurisdiction over the removal proceedings. Now, Judge Erickson could have just granted the application, but she didn't. Instead, she invoked subsection C1 and held a hearing the next day. And at that hearing, she invited the government to introduce evidence, including either documents or testimony, to support those claims.
But the government just didn't. Instead, Judge Erickson says, at the hearing, the court heard attorney argument, but no sworn testimony was taken. During the hearing, the United States offered to supplement the record with information, and the court had questions. The government's answers persuaded the court that the government could benefit from the opportunity for more thoughtful consideration.
Yeah, so credit to Judge Erickson. She's basically saying, no, DOJ, we are not going to take your word for it. And again, I don't know this, but I think that has to be informed by judges across the country seeing DOJ lawyers lie openly in other courtrooms. And I should add, Judge Erickson just took over as chief of this court in January, and the last chief justice was Judge James Boasberg in D.C. That is the judge before whom the Department of Justice lied to his face when he ordered the planes full of detainees bound for El Salvador to be turned around. And they promised, yes, they were. And in fact, they scrambled to get them off and make it a fait accompli. So I can't prove that she talked to Judge Boasberg, but it'd be real weird if she had.
Well, she wouldn't have to, right? It was national news, and it was a Supreme Court. And look, it's not a secret what's happened, you know, all of this conflict between the judiciary and the DOJ, and the way that the DOJ is attacking judges. So Judge Erickson ordered the government to supplement its application consistent with the matters discussed during the hearing, and in addition, provide any further factual or legal analysis to satisfy its statutory obligations by Wednesday. That will be, like everything else in this case, almost ex parte and under seal. We're not going to get to see it, and we're not going to figure out for a while, at least until it comes out, who the person is who is the subject of this. But we will get to see whatever Judge Erickson decides. If she denies the application, she'll have to do so in a public written order, at which point the government can appeal to the D.C. Circuit. If she grants the application, the deportation proceedings will be public, kind of. But at least we'll know who the government is trying to deport under the guise of being an alien terrorist.
Yeah, and you said kind of. I mean, it is designated as a public hearing, but here's the wrinkle. Because this court was specifically created to receive classified information, it uses a procedure that is kind of akin to SIPA, right? So what happens is that the government privately, ex parte, goes and shares the actual evidence with the judge. And then what it gives to the immigrant's lawyer is an unclassified summary that the judge has signed off on that has that confidential national security information redacted.
The slippage here is that most immigrants are never going to get to see the underlying documents at all. If the person that the government is trying to deport is a lawful permanent resident, then the ATRC court has to appoint special counsel with security clearance to review the classified information and advocate on behalf of the immigrant. The lawyer still can't meet with the client, so it's not great, but at least there is someone there to challenge the government's designation. If you are not a lawful permanent resident, though, if you are, say, an undocumented immigrant, you don't even have that right. Even if you have your own lawyer, the government never has to tell you anything. It can just try and deport you in an ex parte proceeding to which you have no access.
Yeah, and that distinction between lawful permanent residents and all other immigrants is, I think, the main reason why the administration is trying out this kind of weird court that's never been used before. So let me draw that out a little bit. One of the things we have documented at length on this show that the administration wants to do is carry out mass deportations of immigrants who have been in this country for a long time, right? Mm-hmm. Who are on the non-detained docket because it knows where they are because they've been complying with the law, right? And by and large, most of those efforts have failed, right? So most recently, we saw that where pretty much every court, 300 plus district courts and everywhere except the 5th and the 8th Circuit have told the administration, no, it cannot use the mandatory detention provisions on every immigrant that's in ICE custody. And one of the reasons for that is actually a 2018 Supreme Court case called Jennings versus Rodriguez, written by Justice Alito, right? And that case draws the distinction between mandatory detention, which applies, this is the wording of the opinion, primarily to aliens seeking entry into the United States, and discretionary detention, which applies to everybody else, right, where you get the bond hearing. So it kind of sets the baseline immigration rule, which says the Immigration and Nationality Act distinguishes between immigrants arriving at the border, who get the lowest level of constitutional rights, and those who have been here for a while. They're not at the border anymore. They're on the non-detained docket, and they get due process. And that's not helpful to Trump. That's what. So I think the reason that the administration wanted to try out this ATRC process is because it draws the line in a different place. It's not based on time in the country. It's not based on geographical location. It's drawn so that only if you're a lawful permanent resident, very, very tiny subclass, you get the protections of due process. Everybody else gets the least amount of due process.
Yeah. So here's the bottom line. This is a potentially worrisome process because we know that the Trump administration is constantly trying to manipulate things to, as we've seen Trump say, these are all terrorists. These Venezuelans are, Tren de Aragua, like a strike force, terrorists that are invading on behalf of the government of Venezuela, which we apparently run now. So I don't know whether that's still a thing. But what they've tried to do is find new ways to expel immigrants from the country by labeling them in some way that will put them outside of due process protections. And so we can't see what this is, but what it feels like is the government grasping for another tool to make it easier to shove immigrants out of this country without the annoying requirements of due process or giving them lawyers or hearings. And so they're pushing on another lever here, is what it looks like. We don't know. We might find out. We might not.
Yeah. And just to expand on that, the statute says that alien terrorist is any person that the Secretary of State determines is associated with a terrorist organization. And who gets to label the terrorist organizations? The Secretary of State. And Liz, you pointed out that Secretary of State Marco Rubio has inappropriately labeled Tren de Aragua and MS-13 and drug cartels as terrorist organizations. They are not. But he's also designated a bunch of left-wing European political groups as foreign terrorist organizations. So Antifa Ost in Germany, the Informal Anarchist Federation in Italy, and two agencies in Greece, right? So look, we don't know who this is targeting. We don't know what supposed terrorist group this person belongs to. But yeah, the potential for abuse there is real.
Okay, that is going to do it for us today. Thank you so much for hanging out with us on the show. We could not do it without you. We would love if you would become a supporter at lawandchaospod.com or patreon.com/lawandchaospod or if you would leave us a 5-star review on your podcast platform of choice. We will be back on Thursday with more written content and on Friday with another show. See you guys.
Law and Chaos Podcast is a production of Raise Ipsa Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Raise Ipsa Media, LLC, all rights reserved.